Welcome back. Now, the criminal justice system, the Administration of Criminal Justice Act of 2015, is a 495 section law that repeals the Criminal Procedure Act and the Criminal Procedure Code as applicable in all federal courts and courts in the FCT. Now, the Act regulates more than just criminal procedure. It covers, in most parts, the entire criminal justice process, from arrest, investigation, trial, custodial matters,
Pause.
and sentencing guidelines. Well, okay, all that's grammar, right? All you know, all that the Nigerian or the citizen or the audience want to know is, when I go to court, what's the guarantee
that I will get justice?
That I'll get justice? How would it work out that I don't have to spend money and it's wasted? Well, but
you don't have to wait 20 years to get your matter sorted.
Yes, and we do have, there's a question I will ask the lawyers when we start. They are here in the studio and I'm going to ask them that question. For instance, and they're laughing.
And right this morning, it's raining lawyers. We've got three of them in the studio.
Although they say they are not the regular lawyers, please join us to welcome Olasupo Ojo, a legal practitioner, John Oloyede, also a legal practitioner, and Chimanaji, another legal practitioner. And I'm sure we have a lot of legal practitioners watching already.
Yes. Almost everybody in Nigeria
is a legal practitioner.
May not necessarily be legal practitioner, but lawyer. They always have opinion to express on legal matters.
Well,
rightly or wrongly.
When I was in secondary school, my teacher asked my colleague a question, and he said, "What do you want to be when you grow up?" And he said, "I want to be a lawyer." And he said, you want to be a lawyer? So that when you see a human head, you say it's a coconut.
That's one of those misconceptions.
Exactly. So because there are a lot of misconceptions out there. So
absolutely.
Let me begin with you, Mr. Lady.
Yes, sir.
What do you think of the Criminal Justice System Act? Administration of Criminal Justice System Act.
Well, it's an act that I would describe as very revolutionary. I mean, like everything Nigerian, it's never been the fact that there is paucity of laws in Nigeria. The Administration of Criminal Justice Act of 2015 is one of the legacies bestowed on the nation by the past administration. It was actually signed into law on the 13th of May 2015. But having said that, it's an agglomeration of existing acts, like you said at the beginning. That there was the CPC, Criminal Procedure Code, and the CPA that was being used in the South. Now, essentially, those acts covered criminal procedure, as in what happens in court when there's a criminal matter going on. But what has happened with the new law of 2015 is that it covers a wider ground. It takes care of a lot of issues, a lot more than what happens inside the courtroom. It starts with arrest and ends up to sentencing. It introduced very revolutionary ideas that were never there before. For instance, you talk about police arrest. There are situations that there used to be a sort of confusion about whether women, for instance, could stand sureties for somebody who has been detained. That used to be an issue. You get to a police station and say, no, you are a woman, you can't bail anybody. You can't bail somebody. This is something that was clearly spelled out in the Administration of Criminal Justice Act, that a woman can actually bail somebody. Now, you can no longer arrest in lieu, as in that you have a man who is suspected of having committed a crime, and then you go on and arrest the wife so that the man can show up. The Act says, no, you can't do that anymore. Now, you also have a situation, before, I mean, we were talking about regular and irregular kind of lawyers. You had a situation where somebody is charged to court, and the person charged to court has, he doesn't want to face prosecution. He doesn't want to go through trial. So they start by filing an objection to the charge. And that objection to the charge can go from the High Court, from the Magistrate Court to Supreme Court. And that can take upwards of 12, 15 years.
Oh, God.
It means the person may never face justice. But now, the new act says, no, whatever objections you have will be taken together after the hearing of the substantive suit, so that the decision on that will be given at the end of trial. These are some of the new innovations that the Act has introduced. So it's more holistic than what we used to have. But that is not all. The situation is the act that we're talking about talks about application in federal courts. So there's a requirement for the states to adopt this act, this revolutionary act, so that it can become applicable in the states. I know Lagos has done that.
Okay, Mr. Ojo, the practicality of this act. He's just somewhat gone into it when he talked about states adopting this act. But what do you see about the practicality of it?
I think, like every other law, it depends on human beings, who we manage it, who we administer it. And some human beings are also subject to the system within which they work. Whether the system is well equipped, whether all the incentives are there, or everything they need are there to ensure that this law works. In Nigeria, we are fortunate we have some good laws. But when it comes to administration and enforcement, that's where problem comes in. This act contains very good provisions, but in reality, Nigerians or Nigeria is yet to begin to reap the benefit of that law due to several factors within the polity itself. If you start from the police station, because that's the first contact in the criminal justice system, the act made provision about the police itself, which affects their conduct, the way they deal with suspects. They have to respect the dignity of their person and so on. And the law also made provision about even confessional statements. When you say you charge somebody, you have done it, you say, yes, I will confess. It says it shall be in writing, then it shall be recorded electronically. So that when the matter gets to court, because our experience has shown that people who confessed in police station, when they get to court, they will deny it.
Yes, under duress.
They will say it was made under duress. But where there is electronic copy of that confession, can then play it to the court immediately, so that we avoid delay as a result of trial within trial.
Okay.
Trial within trial can also go to Supreme Court and also come back. You understand? But now, the problem at the police station is how many police stations has electronic devices. In other crimes, they have special rooms for interrogation. And everything that goes on in that room is recorded electronically. We do have such in Nigeria. And it is part of the reason why the act, maybe the purpose of that act, is being defeated. That is one at the police station level.
Some question marks here and there.
Now, by the time you move from the police station, you move to the court itself. You then encounter a lot of other problems. You have the lawyers will now come in, and lawyers have different approaches. Of course, any serious lawyer must have a strategy for every case, and your strategy depends on the kind of person you are, not the kind of lawyer you are. You understand? There's a difference between the person who is a lawyer and the lawyer.
They may not understand.
Yes.
Okay, you will explain that.
I will explain that.
We'll come back to the difference between the person who is a lawyer and the lawyer.
Himself.
Okay.
Yes.
Let me bring Mr. Naji. Mr. Naji, this act came into effect in 2015. And please correct me if I'm wrong. The vibes I'm getting from this side is that even though it came into effect in 2015, it has not come into effect. It's not being operated throughout the Federation. So some laws are enacted and people take their time to bring it to effect. I mean, let me give you an example. The Controller General, when he resumed, said that the case of married women waiting for Abuja to give approval for them to get passports is now a thing of the past. He said this quite some time ago, and guess what? It is not being effected yet. The problem is still exactly as it was. So, how long do you envisage it should take for the Federation to begin to comply with a law that has been enacted?
Very well. The law is in force throughout the Federation, but it is presently limited to states that will decide to to enact it, appropriate it as its own law. You know, something is in the air. They call it internet. You have a facility to download it. When you download it, you store it. You understand? That's what the states are expected to do.
Okay.
To make it, because the law says the laws made by the National Assembly will be enforced under the Act. So if the states, like Lagos already had one before this 2015 federal law, and is essentially very similar in content, and the objective remained the same: speedy, efficient, and just dispensation of, the criminal justice.